There are many restrictions on what pharmaceutical companies can do in promoting their products. And companies have to always be careful that they're not promoting for off-label uses, that the government's not going to pursue them for allegedly having made false or misleading statements about their drugs. And there are a lot of rules that the companies have to follow about promotion of their drugs and about provision of information, including CER. Now, physicians are fully able to use drugs for off-label uses and are able to rely on all sorts of information, and there are many players out in the marketplace who are communicating information about drugs and how they work, and there really are a lot of restrictions on how the companies do it that don't apply to others. Now, there are certain exemptions in the law for the provision of healthcare economic information to payers, but there's not been a lot of guidance in that area from FDA, and so companies are sometimes faced with not really knowing necessarily what the rules are for communicating that kind of information. Now, there's an important case that was decided in the Supreme Court recently called CER v. IMS Health, in which the court struck down restrictions that the state of Vermont had imposed on pharmaceutical companies using certain information that others could use for the purpose of marketing pharmaceuticals. And the court said that there were speaker-based and content-based restrictions in that the drug companies weren't allowed to do something that others were allowed to do. And they were restricted only when using the information for specific purposes and giving specific messages. And the court struck down those restrictions, and it'll be interesting to see how the principles from that case might apply to other areas of provision of information by pharmaceutical companies to payers or to physicians. The CER case is being considered by the U.S. Court of Appeals in the Second Circuit in a case called Coronia. And in that case, a sales representative has been prosecuted for allegedly conspiring to misbrand a product by engaging in off-label promotion. And the court there is going to have to consider whether the CER v. IMS case has some application perhaps to overturn Mr. Coronia's conviction, because on Mr. Coronia's view, he's being prosecuted for having engaged in speech that was not misleading, and that even if it were off-label, should not result in a conviction. The government's position is that they're not prosecuting Mr. Coronia for his speech, that it's fine for him to speak, but that the conspiracy was in the Coronia case, the government says, was a conspiracy to distribute a misbranded product, and that is conduct rather than speech. I think that these cases could have a really dramatic effect on the ability of companies to convey information about their products, including CER kinds of information. The Coronia case could decide that the IMS v. CER has very broad application in the promotional context, even beyond what was stated in IMS v. CER, and that even in situations where a company is not, where the government says the company is not being directly prosecuted for speech, but instead for conduct that arose from the speech, I think that it could really have a dramatic effect, and it'll be interesting to see how other cases that might come through the court system apply the principles of IMS v. CER.